Hi everyone, and welcome back to my channel. My name is Kimberly and I do legal videos and parenting videos every week. This is part 2 of a series for people who are going through the step-parent visitation process. So if that's you, you should stay tuned to see what we're talking about. If you haven't seen part 1 of the series, you definitely need to go back. I'll link that down below because you don't even get to this stage of 12 factors that the court will consider unless you have made it through part 1 of the video series. The law has recently changed. It changed on July 1st, 2019, and that change made it much harder for parents who are step parents to get some sort of visitation with children that they've had a long-term relationship with. In fact, the court says that you have to be in an extraordinary situation. So please go back, check out series 1, and then come back and watch series 2. If you've watched series 1, here's series 2, the 12 factors that you need to know before you have a case in a Tennessee court.
Into the code, Tennessee Code annotated 36-6-303 contains 12 factors that the court will consider when they are trying to decide whether or not a step parent can have visitation. So let's start with the first factor. So the factor test can be found under subsection E, and there are 12 of them. Let's get started. Factor number 1, the length and quality of the prior relationship between the child and the petitioner. That's the first part. And then the court will also consider the role performed by the petitioner. The court looks at how long they've known the child, the quality of that relationship, and in this case, we would come in and argue that they performed the role of a bio parent during the marriage or during the length of the relationship with the child. So we're going to have to come in and argue that, hey, this person was not just, kind of hanging around, but they were actually in the role of a parent. They attended extracurricular activities. They fed this child. They supervised this child all the time. They treated this child the same as if the child was their biological child. Some evidence of this that I have seen submitted in the past would be photographs of the step-parent with the stepchild, photographs of them at events, maybe some cards that were exchanged between the stepchild and the step-parent, something like Happy Father's Day or Happy Mother's Day, or drawings that the child had turned in that the step-parent had saved depicting them as a family, things like that. We're going to move on to arguing factor 2. Factor 2 is the existing emotional ties of the child to the petitioner. Some of the factors that we're going to go over today overlap, and so if you've already kind of gone in and proven the role performed by the petitioner and the length and quality of the relationship, the quality of the relationship may directly tie into the emotional tie that the child has with their step-parent. Additional ways that we may be able to go in and prove an emotional tie could be text messages between the step-parent and the stepchild. Could also be the presence of things on social media. I know that that's kind of more of an emerging area, but don't overlook that. You definitely want to pull Instagram and Facebook and Snapchat if you saved some screenshots from that. Anything like that from social media can help boost your case and could prove that there is an emotional tie between the child and the step-parent. Factor 3 is the preference of the child. If the child is determined to be of sufficient maturity to express a preference. Now, as we all know, the maturity of a child can vary dramatically from child to child, so you definitely want to make sure that testifying is not going to be emotionally detrimental to them, and that they are emotionally mature enough to express a preference. Sometimes I have seen the judge interview the child in chambers with just the two attorneys present so that they don't feel any pressure from having to testify in front of bio parent and their step parent, or maybe their grandparents and a step parent. Let's move on to factor 4. Factor 4 is the effect of hostility between the petitioner and the parent or custodian that has been manifested before the child. The second part of factor 4 is the willingness of the petitioner to encourage a close relationship between the stepchild and the parent or custodian of the child, except in a case of abuse. Let's move on to factor 5. Factor 5 is the good faith of the petitioner in filing the petition or motion. We have an obligation as attorneys to make sure that things are filed in good faith, but they have thrown it in here as a factor, and sometimes it's something that we may have to include in our brief if there are allegations on the other side that the petition was not filed in good faith. But it's definitely a factor that the judge will consider in determining whether or not the stepchild gets any sort of parenting time with the petitioner. Let's talk about factor 6. Factor 6 only applies if the parent or custodian of the child is deceased or missing. So if the parent or custodian is deceased or missing, the court is supposed to consider the fact that the petitioner who's requesting parenting time is or was the spouse of the deceased or missing parent or custodian. Finally, a factor that should be easy to prove. Grab that marriage license, submit it as an exhibit, and move on to factor 7. This factor is fairly straightforward. The court will consider any unreasonable deprivation of the petitioner's opportunity to visit with the child by the child's parent or custodian. Factor 8 of the factor test is whether or not the petitioner is seeking to maintain a significant existing relationship with the child. So the court may look at how much parenting time that you are asking for. The court could also consider the existing relationship with the child, because it's hard to maintain a significant existing relationship if you don't already have a significant existing relationship. The 9th factor is whether awarding the petitioner some parenting time would interfere with the parent-child relationship or the relationship between the bio parent and the child, or the custodian-child relationship. Factor 10 involves the interactions and interrelationships that the child has. So the court wants to consider as a factor, factor 10, the child's interactions and interrelationships with siblings, half-siblings, other relatives, and step-relatives. So basically, the court is giving you a list of people to call as a witness if, obviously, they're on your side. So you would look at the sibling, the half-sibling, pull them in, get them to testify if they are old enough, and also look at any other relatives and step-relatives. If you have grandparents that have been very involved, or aunts and uncles, the court will definitely consider that as a factor and look at the best interest of the child and see if continuing those relationships is something that will be in their best interest. I would hope that the court would not want to split up a sibling and a half-sibling and prevent them from seeing each other. So I think if you have that, that's a really good factor that is in your favor. The final two factors, factor 11 and factor 12. So factor 11 is any court finding that the child's parent or custodian is unfit. Finally, factor 12 is any other factor that the court deems relevant. So judicial discretion can always be on your side. If you can think of any other factor that is fact or circumstance specific to your particular case, you definitely want to throw that in. So that was the last factor and the end of the replacement section for Tennessee Code Annotated 36-6-303, which is step-parent visitation. Let's do a brief review. We know that this went into effect on July 1st, just like all the other things that we were talking about today. A step-parent who wants visitation with their other spouse's child or with a deceased spouse's child must be prepared to jump through more and more hoops than they've ever had to jump through before. It is no longer sufficient just to show that step-parent visitation is in the best interest of the child. So you're going to have to go down and file a petition or a motion if you have an already pending divorce. And then the court only has authority to grant step-parent visitation in, quote, extraordinary cases. We saw that. That's some super restrictive language. So if the parent or the custodian comes back and decides to oppose this step-parent visitation, then you're going to have to go through all 12 of those factors after the court sets the matter for hearing. Again, you don't need to have an expert witness, but it's probably your best interest to do that. So this amended statute limits the circumstances where the step-parent visitation might occur. Good luck with that, and I hope that this review of the new statute was helpful to you.
Thank you for watching. If you liked this video, please give it a thumbs up and be sure to hit that notification bell so that you can be notified every time we make some more videos like this.